right, hi, welcome back. Attorney Steve Vondran, quarantine edition. So we are hanging out here, and I'm not hanging out. I'm actually working, but a lot of people are working remotely right now, and I am on quarantine day. I don't know what 150. I don't even know what it is anymore, but a lot of work at home. You can see my noodles up there, my top ramen noodles. So just I'm hunkering down. I'm working. I'm trying to get you guys some videos. Some timely things. But have you guys seen this kind of thing going around? This is where people are basically getting in people's faces, shouting them down, trying to demand that they say certain things. This is a picture I saw, and I don't often use pictures just due to copyright issues, but you can see on the bottom here, I put my copyright notice as fair use. So I've kind of transformed this picture. We hate pink. We hate pink. Say it. Say it. So we are seeing things like this right now. And I was watching this, talking to my wife, and I was like, it kind of reminds me of the tort of false imprisonment from back when I was in law school. And so I thought I would do a video of jury instructions. People tend to like my jury instruction videos. And this one will be on the tort of false imprisonment. Now, a tort is a civil wrong, one person to another. That's enough of the video. You know what I'm talking about. But let's go and take a look here at the elements. If I can get to the next element here. Whoops, where'd we go? Okay, here it is. Let me go down just a little bit so we can get a video in here. And so these are the California false imprisonment jury instructions. Now, every state's probably going to have a version of false imprisonment, may have different elements, may have the same elements, probably slightly different. But this is a tort, and this is under the intentional tort section. So for you law students, there's intentional torts, there's negligence, and there's strict liability. But these come from the CACI number 1400. This is a jury instruction from CACI, pronounced Casey. Casey. Does anybody know what CACI stands for? Anyone? Bueller? Anyone? So it's the California Civil, CACI, California Civil. There is a Cal Crim, CA Crim jury instructions for criminal cases. This is civil. This is a civil case, civil tort, but as you're going to see in a second, could also be a crime to falsely imprison somebody, especially for your political beliefs and things like that. My general advice, just tone it down. We all have opinions and beliefs, but I mean, when you get in somebody's face, threaten them, spit on them, kick them, try to intimidate them, try to tell them what to say and things like that. Things just go overboard, and that's what rang a bell in my head today. So here it is, false imprisonment, no arrest involved. Now you can see right here, no arrest involved. There is, obviously cops do arrest people, and there are jury instructions for lawful arrests and things like that. But my law school, I'm trying to just think back to my good old days of law school. It was the intentional infliction of confinement without legal justification. That was my bar exam answer. Intentional infliction of confinement without legal justification. That's what I slapped down. When you see things like this is something that I would maybe expect to see on an upcoming bar exam. Because they tend to do timely things. Okay, so this is one of them. Now, here's a jury instruction. So if this happens, you sue somebody, case goes to trial, they take it to a jury. This is when jury instructions come out, okay? They impanel a jury, they read this to the jury, or you can have a bench trial. I have a video on bench trials if you want to watch that. Google Attorney Steve bench trials. But this is what happens. This gets read to the jury. They decide if a plaintiff can prove their case, or if it's no case at all and a verdict for the defense. Okay, so here it is. Here are the essential factual elements. Plaintiff claims he or she was wrongfully restrained, confined, or detained. As you can see in that photo, when everybody gets around you in a circle and you feel like you don't have any exit, to me, that looks like a confinement. You're not actually free to leave. It looks like you're kind of stuck or surrounded unless you succumb to the threats or demands. So this can be kind of weird. We've also seen this with people's houses, people surrounding people's houses, politicians, things like that, and where they don't feel like they're free to leave. So I'm bringing this out because I'm dusting it off, so to speak, because false imprisonment, I don't, up till now, I haven't even really, aside from the bar exam, I don't really think about this. but it's what's going on today is giving me things to think about. So it is an intentional tort. Here you have, let me back that down just so you can see it. 5 elements here, okay? 5 elements. And if you're on your bar exam, this is what you can talk about. That defendant intentionally deprived. This is an intentional tort. Could be knowing and intentional. And the intent requirement is not the intent to harm somebody. It's the intent to confine. It's the act where you say, hey, let's surround this person and force them to own up or whatever. That's the intent, to deprive a plaintiff of his or her freedom of movement. Now, if that person would have got up and just walked out and everybody cleared the path, maybe not a big deal. But if they're sitting there chanting, not letting you out, you're stuck. We also see this with, I just saw a video the other day, a guy in a truck was going to get gas and he was surrounded by people, and you see this on freeways and things. So I just want you guys thinking about this. This is not proper conduct. It's not proper activity. It's not lawful. Be careful when you're doing it. Parents who know that their kids have these dangerous, wild propensities to do these kinds of things, the parents could be held liable. So talk, teach. I know they're not going to teach you this in school. It's not the kind of thing you're going to learn, but it's an intentional tort by restricting somebody's freedom of movement by the use of physical barriers, force, threats of force. That's the one I have bolded here. The ones that are bolded, I bolded. Threats of force, menace, fraud, deceit, and unreasonable duress. And then I think maybe that the threats of force and unreasonable duress, I think that in the picture, I hate pink, I think that's probably what that person was feeling, okay? 2, element number 2, that the restraint, confinement, detention compelled the plaintiff to stay or go somewhere for an appreciable amount of time, however short, okay? There's cases saying as little as 15 minutes. Now, if they would just come up to the table and leave in 2 seconds going, we just say this, say that, maybe not tortious, maybe not something actionable, maybe not something you would go file a lawsuit on. But if they're there and they're not leaving and everybody's videoing for their social media channels, trying to get a funny clip, whatever they're doing, that could be actionable, okay? So however short, that's open to interpretation, okay? And again, to stay or go. So it could be I want to go somewhere, or they're preventing you from going somewhere, or they're forcing you to stay, like locking you in a room is false imprisonment, okay? There was cases in case law locking you in a room. That's false imprisonment. So those kinds of things, as I say, the old song, should I stay or should I go? Either one. 3, that the plaintiff did not knowingly or voluntarily consent. Now, consent is a defense to this. Legal justification, like a lawful arrest by a law enforcement officer, privilege, those kinds of things, those are defenses, okay? But consent, fraudulently obtained consent is not consent. So if you lie to somebody, trick them, oh, hey, there's $1 million in there. You go, oh, okay, I'll go walk in the room. You go in there, they lock the door, there's no $1 million. Okay, that was fraudulently obtained consent. There's an old saying in law that fraud vitiates consent. Put that on your bar exam. Fraud vitiates consent. Big points here, big points for watching. Make sure you subscribe, especially if you're in your last year, you're going to be taking your bar exam, or your first year. Got a lot of first years now. 4, that the plaintiff was actually harmed. Now, this is a big one. You have to be harmed in some kind of way. Okay, so usually we say in law that, hurt feelings are not compensable. Hurt feelings, usually there's a certain amount of toughness of skin that you have to have in a society. However, things like humiliation, harm to your reputation, emotional suffering, if somebody spits on you or kicks you or pushes you, we also see those things. Somebody maces you, pepper sprays you, those kinds of things. There's another video I have, assault and battery. Now that really, so you could have potentially a false imprisonment, a potential assault, a civil assault, and a battery. These can also all be criminal, okay? So if they're bad enough and you hurt somebody, knock their eye out or rip their ear off or something, don't be surprised. It could be a crime, probably will be, but there has to be actual harm, damage to reputation. As I put down here, possibly the parents could be liable. inconvenience, physical discomfort, humiliation, those kinds of things. And also in California, other states are going to have their laws, check your law, punitive damages. Punitive damages, what are those? I have a video on punitive damages. Google Attorney Steve punitive damages. You will see it's damages designed to punish and deter, so this doesn't happen again. Now that usually requires oppressive or malicious or fraudulent conduct not relating to a contract. Fraudulent, oppressive, malicious, that's your bar exam stuff. Put it down there. That's what you're looking for. Argue the facts. Argue the facts of your case. Okay, so there has to be some kind of harm, as it says. Number 5, conduct was a substantial factor in causing plaintiffs harm. Doesn't have to be the only factor. It has to be substantial factor. These are the 5 elements. A plaintiff bears the burden of proof on each and every item. If they can't do one, if they can't prove one, there's no case. As lawyers, we review these things. We make sure we have a case before we bring it, or it could be subject to a demur. Yes, I have a video on that, so go watch it. A couple other points here. If you find elements 1, 2, 3 above, but you don't find actual harm, maybe 10, 15 minutes later, the gal in the picture gets up and she walks away and says, well, that was really stupid, but nothing happened. She could be entitled to nominal damages. What's that? Nominal damages. You see it here, such as $1. And so nobody wants to go file a lawsuit for $1 and pay attorney fees and do all that stuff. But it's nominal damages, what we say, helps you vindicate your rights. I won. What'd you win? $1. Not exciting, but that's nominal damages for you. 2, my second bullet point here, the plaintiff need not have been aware. This is another law school one. You're sleeping in a hotel room. Somebody locks a door and you have no knowledge. You have no knowledge of it. Now, that may be kind of hard to actually suffer damages if you're sleeping and you're snoozing away, but it's on the books. Maybe that's a case of nominal damages, okay? And my last point here, the crime of false imprisonment is defined by California Penal Code Section 236, very similar, unlawful violation of the personal liberty of another without legal justification. So you can find that in CA Crim jury instructions. But that's it. Plaintiff has a burden of proof. There it is. It's a tort, intentional torts on the book. For you law students, boom, be looking for that. It comes up in weird places. They hide it pretty good. Something like this, okay? And when you see this, also consider talking about assault and battery. That's what we say. It goes together like ham and eggs, assault and battery. Look for these 3 on your bar exam. Spot the issues, as we say, talk about them, weave in the facts, you'll be good to go. Okay, AttorneySteve.com. Hey, guys, let's be kind, let's be safe. We got election coming up, whichever way it goes. We're going to get through this, but, have your opinions. There are lawful channels, lawful ways to protest. There's nice ways of going about it. Destroying cities, my opinion, not the best way to do it. But thank you for watching. This is general legal information only, not legal advice. If you need help with civil litigation, you know where to find me on the web, right there, AttorneySteve.com, the first name in legal services. Have a great day. Gotta run. Gotta get to my cooking some noodles here. So we'll talk to you later. Bye now.